who is the plaintiff against Loud Silence Media and Kevin Taylor, who are the defendants. Now, what I'm going to do now is I am going to read the ruling. Now, to sum it up before I start reading, you have to understand that the judge has dismissed the case Kennedy Agyapong took to court. He has dismissed it. Now, but what we need to do is to read for you to also know what the judge actually said, the basis of the case and how he came to his conclusion. And Kennedy has 60 days to, and I'm talking about Kennedy's lawyers, they have 60 days to appeal this ruling. So they still have opportunity to go out there in 2 months to let the judge know whether what he came up with wasn't the right ruling. And this is America. You have the right to appeal if you feel that judgment didn't go well for you. So officially, I would like to tell you that Kennedy Agyapong's case against Loud Silence Media and Kevin Taylor has been dismissed for now. So they have 2 months, 60 days to respond to this. Now, let's read this. I'm trying to be very nice here, and we all have to be nice at a point in life. So this is it. Let's do this. When you take the front page of the ruling, this is what is there. I might get some of the words wrong, but pardon me, I'm Ghanaian. I'm not American. I'm not English. That's not my first language. So I'll do my best to read it the way I can. If I get it wrong, I will try and correct those words. Now, when you look at the case here, I'm saying that case, the case action number is 121 CV 1205. 121 CV 1205. I hope I got it right. The legal guys, if I got something wrong, just tell me. Now, if you want to also get access to this document from the United States District Court for the Eastern District of Virginia, you can go on pacermonitor.com. pacermonitor.com. When you go there, you will find this. I hope they have updated it, but if they haven't, tomorrow when you go there, you will see the case between Agyapong and Taylor. Now, let's read this for the world to hear. This is strictly the case between myself and Kennedy Agyapong and Loud Silence Media. Wow, Shemino. Maybe some chemo tree kakra na yentoa asem no so. Enyumbre mabaha no case ana between me and Kennedy Agyapong. Your court Kennedy say maka nsem bi egu no ho fi a or the 3 count bi e court say in America for NG $9.5 million. Emfiri me ho emfama na if we say megu no ho fi na judge a otena asem no so no ende enode na no asem aba ano asem ode ba na say Kennedy asem no wabo atu egu wama no 60 days say onko hwem say bibi ento na koma so ana say ohu say asem no wabo atu egu no say bio judge no andwini hu ya na say results na ba he is not comfortable with it. He can appeal his amendments inti enyumbre me pese me kache Ghana fo nyina say Kennedy Agyapong asem ode court no judge no abo atu egu na me ba be read the ewo the ruling nim se ne be ya obia be hu de judge no ekaye ye wi amebo ne tofa na Ghana fo nyina ehu eye de esi ewo United States of America inti wa hanyumbre ya breaking news no me ba be chechire ma Ghana fo nyina ehu de echo. All right, let's start the case. Now, in the United States District Court for the Eastern District of Virginia, Alexandria Division, Kennedy Ohini Agyapong, plaintiff, Loud Silence Media LLC et al. That is defendants, myself and Loud Silence Media, and ana ye a defender who ewo sa assembly. Now, mama yen kind the judge no atro a 8-page document, so it's going to take a bit of time, but that is what we are doing tonight. We are not doing anything else. After that, the show will end. I'll be back tomorrow to do the normal with all due respect. Now, order, introduction. I'll say this matter comes before the court on the defendant's motion to dismiss amended complaint. Now, the motion has been fully briefed by the parties and is now ripe for consideration. Background. It says the plaintiff in this case, Kennedy Agyapong, is an individual who is a citizen and a resident of the nation of Ghana. Agyapong is an elected member of Ghana's parliament and is the chair of the board of Ghana Gas Company Limited. The defendant in this case are Kevin Taylor, an individual, and the company Loud Silence Media, LSM. Taylor is a resident of Virginia and currently lives in Alexandria, Virginia. Taylor is the founder and manager of Loud Silence Media, or LSM, which is a limited liability company organized in Virginia and and that it has its principal place of business in Alexandria, Virginia. Taylor appears on several news shows broadcast over the internet, website, YouTube, and Facebook. Taylor and LSM produce news media that focuses on the people and politics of the country of Ghana. One of the shows produced by the defendant, let me change it to the second page so that we can follow it. Yeah, there's the second page. Taylor and LSM produce news media that focuses on the people and politics of the country of Ghana. One of the shows produced by the defendant is titled With All Due Respect. Taylor is the host and presenter of this show. The show streams live video broadcast on Facebook and YouTube to a large audience. The plaintiff has alleged that Taylor has made several defamatory statements on this show and further alleges that these false accusations were intended to humiliate and disparage the integrity of the plaintiff. Based on these statements, the plaintiff has filed the current civil action in this court. The first allegedly defamatory statement that the defendant made was an accusation that Agyapong is connected to the 2016 murder of a Ghanaian member of parliament. Taylor has also accused Agyapong of being responsible for the murder of a journalist who had reported on corruption in the Ghana Football Association. Taylor has accused Agyapong of using fake green cards to help Ghanaian citizens immigrate to the United States. Taylor has accused Agyapong of trafficking in illegal drugs. Taylor has accused Agyapong of being addicted to illegal drugs. Taylor has accused Agyapong of financial corruption. Agyapong has alleged that Taylor has repeatedly made the continues to make these statements as recently as September of 2021. Agyapong alleges that Taylor knew these statements were false and that these statements were made knowingly and recklessly. Based on his litany of disparaging remarks, Agyapong has filed the amended complaint with count for defamation per se, and 3, violation of the Virginia computer crime. Page 3. Legal standard. To survive a motion to dismiss under Federal Rule of Civil Procedure, that is 12B6, a complaint must contain sufficient factual allegations that will state a claim to relief that is plausible on its face, if those allegations are accepted as true. Now, a motion is dismissed pursuant to Federal Rule of Civil Procedure 12B6, that is, must be considered in combination with Federal Rule of Civil Procedure 8A2, which requires a short and plain statement of the claim showing that the pleader is entitled to relief, so as to give the defendant fair notice of what the claim is and the grounds upon which it rests. When a well-plead complaint only infers, and I quote, the mere possibility of misconduct, end of quote, the complaint does not demonstrate a plaintiff is entitled to relief. And as you can see, they are stating other cases. The judge is stating some cases as references. So those ones, I don't want to talk about it. It's going to slow you down. We are not lawyers. We are reading what is here. Now, he goes on to say this. When a well-pleaded complaint only infers, and I quote, the mere possibility of misconduct, end of quote, the complaint does not demonstrate a plaintiff is entitled to relief. Pleading that are merely labels and conclusions will not be accepted as true. District Court may also consider materials attached to the complaint so long as their authenticity is not challenged and the materials are integral to or relied on within the complaint. Now, discussion. That is page 3. And this is what is in the ruling. Some of them are very technical, so I have to try and make it try and sound like I know grammar. I'm doing my best here. Page 3. To survive a motion to dismiss under Federal Rule of Civil Procedure, that is 12B6, a complaint must contain sufficient factual allegations that will state a claim to relief that is plausible on its face. If those allegations are accepted as true, no, sorry. Where are we now? Page 3, right? No, sorry, page 4. Sorry, page 4. It goes on to say, as a public figure, Agyapong must demonstrate that Taylor made the allegedly defamatory statement with, in quote, actual malice. It says, as a public figure, Agyapong must demonstrate that Taylor made the allegedly defamatory statement with, in quote, actual malice to recover damages for defamation. Now, he stated other cases, New York Times, Sullivan, and all that. He went on to say this. Actual malice does not mean that the defamatory statements were spitefully made, but rather it means that the statements were made with knowledge and statement with knowledge. The statements were false, or that the statements were made with a reckless disregard for their veracity. I'm sorry. Let me take this again. Actual malice does not mean that the defamatory statements were spitefully made, but rather it means that the statements were made with knowledge, the statements were false, or that the statements were made with a reckless disregard for their veracity. A reckless disregard is shown when the statements are published, and I quote, with a high degree of awareness, end of quote, that the statements are likely to be false. Now, at the motion to dismiss stage, the amended complaint must allege facts from which the court can infer that Taylor acted with the requisite state of mind. That is, to plead actual malice buttresses point here. That's what I'm saying. It's a bit complicated. Let's take our time and read this. Now, when you go to the next paragraph, it says, Agyapong has not played sufficient factual material to show that the statements were made with actual malice. Agyapong alleges that Taylor knew the statements regarding the murders were false because other individuals were arrested for the murder, and Taylor has not verified a video that was published on his YouTube show. It is true that avoidance of the truth can demonstrate actual malice, but a mere failure to investigate does not demonstrate actual malice. Let me take this line again. It is true that avoidance of the truth can demonstrate actual malice, but a mere failure to investigate does not demonstrate actual malice. Now let's go to page 5. Page 5. It is apparent from the statement themselves that Taylor is referencing that he believes Agyapong is responsible for the murders, not that Agyapong pulled the trigger himself. He says that it is apparent from the statement themselves that Taylor is referencing that he believes Agyapong is responsible for the murders, not that Agyapong pulled the trigger himself. In addition, the YouTube video referenced in the complaint prominently displays a news article that refers to a government investigation into threats that Agyapong made to other journalists. The materials referenced in the amended complaint and the amended complaint itself demonstrate that Taylor had at least some factual basis for his political commentary. The amended complaint only makes conclusion and pleads factual material that challenge the veracity of Taylor's statement. The amended complaint does not plead any factual material that sheds light on Taylor's subjective state of mind. Therefore, the amended complaint and the materials referenced within do not create any plausible inference that Taylor harbors, and I quote, any doubt as to the veracity of the story, end of quote, or to the unverified video's credibility. The pleadings regarding the statement about Agyapong committing immigration fraud are similarly deficient. The amended complaint argues that, and I quote, the crime defendant fabricated and all falsely associated with plaintiff is practically impossible. End of quote. The amended complaint goes on to argue that it is essentially impossible to acquire a fake United States green card because of the sophistication of the United States immigration system. These pleadings do not support any inference into Taylor's state of mind, and at best, they are accusations that he failed to investigate the claims. These pleadings are also conclusory and, as such, need not be considered as true. Without any pleading that could be considered for circumstantial evidence of Taylor's state of mind, the pleading regarding the alleged immigration fraud do not sufficiently allege facts that shows Taylor's reckless intent or otherwise demonstrate actual malice. Page 6. The pleadings regarding public corruption, drug trafficking, and drug addiction similarly do not allege facts that shows these statements were made with actual malice. The pleading that Agyapong was never arrested for drug trafficking and therefore is not a drug trafficker is a conclusion. The pleading that argues Agyapong does not exhibit signs of drug addiction and therefore cannot be a drug addict is a conclusion. The pleading that the supposedly corrupt government contract was publicly available information and therefore Agyapong could not have schemed public funds is also a conclusion. None of the conclusory pleadings need to be considered true by the court, and furthermore, none of these statements allege any facts regarding Taylor's state of mind at the time he made the allegedly defamatory statement. None of the pleadings demonstrate facts that shows Taylor acted with high degree of awareness of the falsity of his remarks when the statements were made. In Fairfax, the Fourth Circuit rejected the argument that doubt about a witness's credibility made the publication of that witness allegations, and I quote, so obviously doubtful that the news organization was reckless in reporting those allegations. It goes on to say this: as it is the case here, the conclusory pleading only challenge the credibility of Taylor's statement and at best allege a failure to investigate. Accordingly, the amended complaint does not plead any fact that shows the statements were so obviously doubtful that Taylor acted recklessly when making the defamatory statement. Therefore, none of Agyapong's conclusory pleadings imply a plausible accusation that Taylor made the defamatory remarks with actual malice. As Agyapong has not sufficiently pled that the statements were made with actual malice, the claims for defamation and defamation per se cannot be brought against Taylor because Taylor is immune from civil liability under VA Code 801223.2. That is page 7. It says defamation and defamation per se cannot be brought against Taylor because Taylor is immune from civil liability under VA Code 8.01223.2 and the protection granted by the First Amendment of the Constitution. Accordingly, the amended complaint must be dismissed because it does not state a claim upon which relief can be granted. Now you go to the Virginia Computer Crime Act. Agyapong has also claimed damages under the provision of Virginia Code 18 blah 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 to show a violation of this Virginia law. Agyapong must plead facts that demonstrates the requisite element that, and I quote, the accused used a computer or a computer network to communicate obscene language. 3. 1. The accused used a computer or a computer network. 2. To communicate obscene language. 3. With the intent to coerce, intimidate, or harass. Now, Obscenity has been defined by the Virginia General Assembly as material that, and I quote, has its dominant theme or purpose an appeal to the prurient interest in sex. That is the Virginia blah, blah, blah. Explaining that the Virginia General Assembly wrote the statute to comply with the constitutional definition of obscenity articulated by the Supreme Court. Now, the amended complaint contains no pleading that can be constructed to show that Taylor communicated obscene language as defined by the Virginia law. There is no reference to any sexual material in the communication detailed in the amended complaint, and the dominant theme of the disputed communications in no way contains any sexual themes. The allegations within the amended complaint do not support any claim that could be brought under the Virginia Computer Crime Act. Count 3 of the amended complaint must also be dismissed for this reason. Now, page number 8. The final page is this. Conclusion by the judge. It is undisputed that Agyapong is a public figure and Taylor's statements were made regarding matters of public concern. The amended complaint does not plead any factual material that demonstrates Taylor's dispute statements were published with actual malice. Therefore, Agyapong has not adequately plead any actionable claim. Further, the amended complaint does not plausibly state a claim under the Virginia Computer Crime Act. For these reasons, the motion to dismiss the amended complaint, that is DKT 13, is granted, and the above captions civil action is dismissed. The plaintiff has 60 days to file a second amendment complaint if that filing would meet the requirement discussed in this order. It is so ordered. March 21st, 2022, Alexandria, Virginia, Liam O'Grady, United States District Court. Now, the conclusion says it is undisputed that Agyapong is a public figure and Taylor's statements were made regarding matters of public concern. The amended complaint does not plead any factual material that demonstrates Taylor's disputed statements were published with actual malice. Therefore, Agyapong has not adequately plead an actionable claim. Further, the amended complaint does not plausibly state a claim under the Virginia Computer Crime Act. For these reasons, the motion to dismiss the amended complaint is granted and the above captioned civil action is dismissed. The plaintiff has 60 days to file a second amended complaint if that filing would meet requirement discussed in this order. It is so ordered. March 21st, 2022. Signed, Liam O'Grady, United States District Court. So, ladies and gentlemen, this is where we are with the Kennedy Agyapong Kevin Taylor court case. Before I started the show, I said you can access this document. This document will be published on loudsilencenews.com on our website. It will be published on With All Due Respect page on Facebook. It will be published on all our news sites. It also will be published on pesamonitor.com. That's where all the legal cases that have been concluded are published. So when you go to pesamonitor.com, Pesa, PACERMONITOR.com, if it has been updated, because this ruling came today, it takes some time for them to update that system. So if it has been updated, when you go there, you will see this document there. It's an eight-page ruling. We will, after the show, we will publish this document on loudsilencenews.com. It will be published on With Audio Respect page on Facebook. It will be published on all our news outlets. So that is it for now. So Kennedy Agyapong still has the opportunity. If he thinks all that the judge said, some things were not said right, or the facts the judge put there are not things that does not really make sense to him, he can file an appeal. Myself and my legal team, my lawyers, we are on standby to hear from Kennedy and his team. This is America, and you have to understand that the law works, irrespective of who is in front of it. So, to respect to the law, respect to the judge, respect to the judicial system, we wait and see. But as we speak now, the case between myself, Loud Silence, the case between Kennedy Agyapong, myself, and Loud Silence Media has been dismissed. And we wait for Kennedy to take the next action. Ladies and gentlemen, that's all that I would say on this case. Inti, mo asibio brofo bebreba me kan na monti ase no. Kennedy Agyapong ede me call court no. Ono na ede asem call court se me gu ne ho fi na ope $9.5 million. Court NG na court embua me for na court engu medwuma no ene nsem bebre a ochroye. Ochrochro say me say oton cocaine, me say we kun journalist, me say waye nyoma bebre, o se me the computer abo krono e de a church nyoma mu ani se de ye. Na judge a oti case ne so no ende obaye no ka se nsema Kennedy beto court enim ni nyina no ohwema ba kumponi wa wo embrema sebi obetumi gina so e de akase na asem no sebi etwaye enti otoa so. Osamuti ase se Kennedy e de asem no e court no or ye amendment ye kase or ye amendment a or de na asem e din kan court no otwe asem no e na osako eko correct ye sa na betuma kama wate ase ye kase obi di asem akọ na wa ye amendment a ebia asem ode koye no ono adadwene ho no hu se asem ya metwere koye na me lawyers di menim koye sebi ebi wo ha ento asum ebi wo ha sebi enya asem a court betumi gina so e di ama me de mepe enti otwe every court e na osako sese mu kotwero ni biem e koye amendment e na osade baaye enti judge ni gina na amendment no so because first one or trouble no so ode ukoya amendment automatically the wakoya amendment aba no eno na court no ehwe enti court no ejina na amendment no so ana judge ni gina amendment no so eno odi bu asem no na de na judge ni kanya se ensama Kennedy kire ye e won amendment mu nyina no enin gina so bia. In fact, in some kind nyina dodo no na public in some ye discuss public issues and when to me answer that and to me an kire adekodi entia nsema mekai no na opese o kire se na adwene bone ana adwene bone bi eta akiri a me pese be good anim ase ana se me ma ne bra e basa nti judge no etina ka se wakenkan obi ansem yeso e kire yensem koye na George ne kan yensem na o se Kennedy eni asem bia wa ha sebio obeso ka che Kennedy se nsem na odoba na nsem hunu ontumi ngina so e wa America krowe mu we ye American court sebio we nya Ghana court we ye quarter e wa America sebio oma omudi enim no judges no oma ye kukudam oma nhwe wanim ansa no mobu asem sebio untumi nkofre no baby say ma asem da ha ntiboa me judge fo ye nipa bi a sebio emra ne wa ha ne eye adwuma nti no sebio emfa ho ne wodibre ene sebio baby a odwen se wo omode asem no emra no na omudi enti se court e wo Ghana sebio se wuni mobi okota yebetumi bu amaw enti judge na kire se America nan adekodi enti efra America ya America ne se eye the upholding the laws of the land no omufendi agro enti eho na asem na ko se enti ne krakra ne se judge na abo Kennedy asem na togu se wama no eye bosumi mienu se onkodwene ho na ode de bibi ogina na ogina Kennedy ntuma nkire bibia won nkrate ma kire se o wasem papa bia o se ogina so ono anepe so persisted days no onye na amendment no onsa amend ya na so onya appeal na nhwe na utie the judge ne kan de kasemu na opeso kire na dwene mu fine 100% say there is no way a sebio obi betuma beka bibia kire na a kire say na se Kennedy ewo evidence bia eso chen de odi ba ye ya owo ngina so bia eso chen de wodi abeya onko famra na nkire say asem no odibem enti me no ka say de eye Kennedy Agyapong ene Kevin Taylor ne Loud Silence Media asema na ewo eye federal court no court judge your friend no eye honorable Liam Ograde wabo asem na tuogu